Mr. Speaker, I move the substitution.
Assemblyman Danielson moves the substitution. Assemblyman Danielson, you still have your light on? No? Oh, okay. All those in favor of signify by saying aye. Opposed, nay. So moved. Madam Clerk.
On third reading and final passage, Senate Bill 2930 makes various changes to process for access to government records.
Assemblyman Danielson.
Mr. Speaker, I move the bill.
Assemblyman Danielson moves the bill. Assemblyman Danielson, you have your light on. You want to speak?
Thank you, Speaker. I'm sure everybody in this room will declare themselves an advocate of transparency and open government, and I'll accept that and agree with that declaration. We are here today because of big problems with the current statute. This statute was written 22 years ago, was poorly written then, and its problems are only getting worse. I believe we can fix those problems while improving the public's access to government documents. We've been working on modernizing OPRA through this bill for a very long time. We held meetings, hearings, work sessions. We also sat with interested parties and organizations and with a nonpartisan group. No one walked away empty-handed or getting everything. To say this was a rubber-stamped or a fast-track bill is just simply wrong. The main goals of this bill include increasing access to government documents, protecting your privacy, protecting personal identifiable information, stopping the profit abuses, leveraging the internet, and setting standards for OPRA that align with current legal practices. This bill serves to protect the taxpayers' rights, resources, and its money. In my review,
order in the chamber, please.
I see the vast majority of all OPRA requests getting processed completely and successfully. And this bill does nothing to change that reality. Rather, this bill improves document access and lowers the cost of providing access to those documents. This bill also protects some of the costs of commercial requests and takes those costs away from the taxpayer and assigns them to the commercial entity. We are also here because of the mounting abuses and profiteering that is going on with OPRA. These are costs for which the taxpayer also pays. For years, we watched agencies get flooded with requests by commercial entities, data miners, and even law firms. But we also observed what seems to be an army of abusers who have teamed up with attorneys to weaponize our own laws. We've stood by and watched our local, county, and state agencies get taken advantage of using the flaws of our current statutes. The courts are now in a position to interpret an out-of-date statute. We now have cases that demonstrate agencies not being able to charge a reasonable fee to produce documents which generate exorbitant costs. We have cases that have gone through all levels of the court system to the Supreme Court, only being appealed to argue over attorney fees. And these cases are cases where the documents have been completely given to the requester. Let's look at the most recent attorney fee demand by an attorney. $800 per hour. Let that sink in, including fee enhancements. And this attorney insists on defining the word transparency by a guarantee it gets wealthier at an increasing rate. $800 per hour. The current practice and model of OPRA, let's get this clear. The current practice is that if a requester or its attorney can prove an agency was less than perfect under OPRA, they prevail. They also prevail even when a judge gives a requester something they weren't asking for. They prevail. They prevail when they get the slightest minutia of a request, and that results in an $800 an hour fee. Also, the judge has no discretion in that matter. The judge's only discretion is the number of hours and the rate per hour. This bill does not eliminate attorney fees at all. This bill does not eliminate attorney fees at all. This bill simply modifies the full guarantee in the current practice by giving the judge the discretion to assess if the case merits attorney fees at all. The exception to this is cases that are deemed to be in bad faith. Let's not forget that most of these costly cases follow hundreds, if not thousands, of requests by the same requester, their clients, and are now only the tip of the abusive iceberg. This bill now requires all documents to be posted on the website where feasible. That gives 24/7 access to the entire world. This bill has an exception where the cases that are, this bill requires the Government Records Council to adjudicate all cases within 90 days and to produce an annual report to the legislature so we can effectively monitor its success or the lack of success. I'll also remind you, GRC was created in most part to be an informal court system where someone can submit a complaint easily without the need for an attorney. And these skilled professionals will adjudicate these cases in a cost-effective manner where you don't need an attorney. And that is still true today. This bill removes anonymous lawsuits. Just think about that. It's bad enough that anyone in the world with an email address can abuse our Open Public Records Act just because they have an email account. And they could sue anonymously. This bill changes that. This bill sets standards of what shall be included at a minimum in an OPRA request and requires the Government Records Council to update those standards annually. Requests that are submitted and never picked up. I make note of this because there are cases of abusers that will submit an OPRA request and generates reams and reams of paper, banker boxes after banker boxes stacked up, and they never pick them up. And it requires the custodian to keep those boxes there indefinitely. This bill solidifies a requester's right to appeal and supports it by requiring the custodians and agencies to publish on every single OPRA form and every single website a citizen's right to appeal, the instructions, and the contact information to the Government Records Council. This bill establishes a statute of limitation. The importance of that is because the practice of the abusers now is they will submit an OPRA request, and they may hold on to it for 4, 5, 6 years. People die, retire, move away, and then they submit the lawsuit, having the participants not even having the option to defend themselves. They don't want us to change that either. This bill also addresses litigation that's filed so quickly, whereas if you are an hour late, a day late, there's some people that file that lawsuit that hour. Well, those cases should be dismissed, but it gets even worse. There is an organization in New Jersey that will submit hundreds of OPRA requests, file one lawsuit, then submit another 12 that same week. Before you even can look at those cases, You get a call from a person in this organization asking for a cash settlement with the understanding that they will eliminate all lawsuits from the flood of their requests if you pay them a cash settlement, skirting around the attorney fees. And that is a threat that happens every day. Yes, this bill includes a protective order. You know, in every group, you got crazy. New Jersey certainly no exception to that. And there are some abusers that are so bad, that are so costly, that are so unapproachable with reason, that they stranglehold the taxpayer's government agency. It gets bad. I don't know if you've ever had the unfortunate
Assemblyman,
occasion.
you have 5 minutes remaining.
Personal privilege?
Well, you have 5 minutes remaining. You have 15 minutes to talk. You have 5 left.
Oh, okay.
Well, now you have
All
a little less.
I got 5 minutes left. It'll only take me 6. The protective order. You may have heard some people misstate this section of the bill where we're going to sue people. That's not the case. What the case is, it gives the agencies a statutory standing to initiate an application for protection. In order for them to achieve that, the agency must prove intent, and they must prove substantially impairing the performance of that agency. That's not easy to do. They also must use clear and convincing evidence to the judge before they can begin considering that application to an unbiased Superior Court judge. Those are very difficult standards, but in some cases, these abusers will make it easy. Furthermore, the agency must collect everything, all the facts, and produce a declaration of those facts. The agency must also prove they were in full compliance with our OPRA laws and that they attempted, but unsuccessful, to resolve in good faith the problems with this requester. Then, the judge can, for example, limit the number of requests by that one requester. The judge could limit the scope of that requester, or simply the judge can limit or expand the time the agency has to respond to this requester, or the judge could simply deny the application. There are cases where there are agencies that need this protection, which sets a high bar and clear standards. Ladies and gentlemen, this is a good bill that continues to protect transparency, continues to protect citizens' rights, and continues to protect the taxpayers' resources and money. Thank you.
Thank you, Assemblyman. Assemblyman Bergen.
Mr. Speaker, will the sponsor yield for questions?
Will the sponsor yield for question? No.
Is he scared? No? You want to answer that? Okay. I wouldn't either if I was him. Mr. Speaker, on the bill.
On the bill.
Mr. Speaker, I really love being here in this chamber, and it means a lot to me to be here, but it's days like today which cast doubt for me on the whole thing. It's this type of bill that really erodes the public's trust in us. I mean, the sponsor of the bill is well known to have been ducking questions by the public for a long time and won't even answer them here for me today, his colleague in the chamber. And I don't blame him, because, Mr. Speaker, this bill isn't just bad. This bill is malicious in its intention. Mr. Speaker, we have a job to protect the public. It's our job to stand up for those who can't stand up for themselves. Today, we've forgotten that. No logical person who has spent any time actually reading any of the 27 pages in this bill would even consider voting for it. It's impossible, because the atrocities in here are too many and they are impossible to miss. Mr. Speaker, where we sit today with OPRA is the result of 40 years of progress. For those of you who may have actually looked at the bill, you'd see sections referenced in Pamphlet Law in 1963 is where it started. And then Pamphlet Law in 1995, it got better. And then in 2000, it got better. And after 40 years of constant progress, today we have a sponsor and people behind the sponsor trying to rip apart the protections for these employees. But I have to admit, it's been a brilliant PR campaign. You've been using the municipal clerks and the burden on them and the burden on the mayors as your way to jam through some really catastrophic legislation, pulling at our heartstrings because we feel bad for them. But they are a small part of what OPRA covers, like the tiniest little part. Everything that you do in this bill applies to all state agencies, county governments, school boards, and anybody who's ever gone to a school board or a council meeting or a board meeting of any kind, and you stand there and you ask questions, and they look at you like you're transparent, and they tell you to sit down when the public's over, and they just move on. OPRA is designed to allow you to access the information that they won't give you in the public. On its merits, this bill is horrible. And here's the truth, and it's an unfortunate truth. Almost every yes vote that you're going to get today is either threatened to be that way or bought to be that way. And it's disgusting, Mr. Speaker. Here's what the bill does not do. The bill doesn't in any way, shape, or form limit any commercial requests. It doesn't get rid of any data mining. All the stuff that you started with this bill to get all the clerks behind you, it doesn't do any of that anymore. It doesn't reduce the volume. The municipalities and the counties and the school, they're going to get the same volume of requests. There's not a thing in this bill, and I challenge anybody here to point to one thing in this bill that would do anything to actually limit the volume, with the exception of the litigation threat that's in Section 8. Here's what it does do. The bill oppresses the public. And for those of you progressives in this chamber, I have no idea how you rectify this with yourselves, how you can stomach this. This denies people access to documents through the fear of litigation. Forget the rosy fake picture the sponsor painted of that Section 8 in here, which is now Section 7 in the revised copy. The reality is, it gives a government agency the right to sue you for putting in OPRA requests. And that's the truth. This bill also spends $10 million. A couple minutes ago, people were up complaining about school district cuts. Everybody in this chamber's got up their violin. Oh, my school district is losing money. But then you spend $10 million on this? The rationale blows my mind. And for those of you who might have taken the time to research it, this also is going to be $96,000 a year in salaries for the Government Records Council, which has existed for 20 years with not paying them anything. And since I'm assuming somebody has a job they want to give somebody, it removes the prohibition against you being a public employee. So a public employee can be on the Government Records Council, get paid $12,000 a year, and add that to their pension. So we're probably paying them $6,000 a year for the rest of their life, which is insane. Mr. Speaker, this bill kills 40 years of progress. If you vote for this bill today, ladies and gentlemen, you are part of the problem. You are the exact person that people don't trust. You are the exact person that protects the interests of government and simultaneously stomps on the people. You are the problem. And if you're voting for this bill for any reason other than you think it's a magnificent idea, if you're voting for it because you're nervous about someone putting up somebody to run against you, or because the speaker forced you to vote a certain way, or because now you get to have a bill put up that you negotiated for, you should be disgusted with yourselves. You're a pawn, and I'm embarrassed for you. Ladies and gentlemen, this bill is awful. It's disgusting. it represents everything that the people think is wrong with government. And I'm embarrassed to be here today even talking about it. Thank you, Mr. Speaker.
Order, order, order. Assemblywoman Fantasia.
Thank you, Mr. Speaker. On the bill?
On the bill.
I, too, rise to speak in opposition of this legislation. I've served at the local level as a borough councilwoman and on various boards, zoning board, land use board, as a county freeholder and then commissioner, and 18 years as a public school employee, so I do understand OPRA quite well. I understand the expenses. OPRA is a mandate, mind you, a worthy one, but still, we must consider its costs and its ramifications. I understand the need to streamline and modernize some of the processes and assist local governments with some of the commercial abusers of the current OPRA law, who cause countless amounts of work hours to comply with OPRA requests to make corporations money. But this legislation does not just address that. It goes way, way beyond that. You know what I worry about in this bill? I worry about a working class parent of a vulnerable child, and the parent files an OPRA request to figure out why there were no responses from the school for a bullying situation, or why they feel their child is being mistreated, or any curriculum requests by a parent, and those requests are wrongfully denied, and the parent doesn't have the money now to afford an attorney to act on the parent's behalf, to get these government records. And no attorney now is going to want to take this case because of the removal of the mandatory payment of attorney fees for successful denial of appeals in this bill. But more importantly, this hits home in Sussex County. We all heard of the horrific loss at the Andover subacute nursing home during the early days of the pandemic. In May of 2020, I was the deputy director of the board at the time, and our county council, on behalf of myself and the rest of the Sussex County freeholders at that time, we filed OPRA requests with the state of New Jersey regarding this tragedy. The governor at the start of the pandemic issued executive orders blocking the release of certain information due to the public health emergency, and we were denied. So Sussex County sued, and it is now, 4 years later, May of 2024, and Sussex County is still in court with the state, is still fighting tooth and nail, who continues to try to prevent to release the information during that time. And do you think this bill addresses any of that? No, not one iota. Us as freeholders, we cooperated fully with all investigations. All emails, all correspondence, we released it all. And do you know how much the public believes in OPRA in Sussex County? We made it a referendum question. We put it on the general ballot out to the public and asked the public's permission to spend Sussex County taxpayer dollars going after the New Jersey Department of Health to get access to those public records, and we won resoundingly. There was a chorus of the public saying, yes, we demand those records, and we are willing to sacrifice our taxpayer dollars, our resources, to get that information from a state that's withholding it. So I hope you understand my position that when we talk about OPRA reform, you know what would be really great? A bill that was not deeply flawed. A bill that does not allow the government to sue requesters who are simply requesting information. A bill that does not allow lawyers to charge exorbitant fees. And a bill that does not automatically deny an anonymous requester's appeal. Again, there is definitely need for OPRA reform, and I commend the sponsors of this bill for recognizing that, and I appreciate the sponsors of the bill for recognizing that. But from my neck in the woods, this is bad legislation, and I urge all my colleagues to please vote no. Thank you.
Thank you, Assemblyman Azariti.
Thank you, Mr. Speaker. On the bill?
On the bill.
Thank you. I rise today in opposition to this OPRA reform bill. Having served in municipal government, I'm empathetic to the need for significant OPRA reform and modernization. OPRA is all too often abused by various parties for various reasons. We acknowledge that. I've seen, particularly in small municipalities, how abusive and redundant OPRA requests burden the municipal staff, diverting them from the work of the people they serve. I also acknowledge that OPRA abuse incurs significant financial burdens on municipalities and others. There is no doubt that OPRA must be reformed. But reform that reduces transparency and accountability only serves to reduce trust in government by a public that already distrusts government immensely. And that's what this bill does. It makes government less transparent, less accountable to the people. In a free society, whenever there's a question before us related to government accountability, we must always err on the side of more transparency and accountability, not less. And in this digital age in which we live, I believe we can reform and modernize OPRA to make it less burdensome and less costly to governments and agencies that are subject to it, while maintaining the highest standards of transparency, disclosure, and accountability. So I believe if our constituents were here in the chamber today and voting, I really sincerely believe the vast majority of those people would be voting no. And so I urge my colleagues to do the same. Thank you, Mr. Speaker.
Thank you, Assemblywoman Flynn.
Thank you, Mr. Speaker. I first want to thank the sponsors of this bill who took the time to listen to a number of the requests I had made on behalf of myself, my colleagues, and my constituents. While we can't always get everything we want, we got a lot that we needed to address the abuses that have happened with OPRA, as well as to encourage greater transparency. I want to thank also the advocates who came out and also pushed this bill into a better direction. I don't think it was ever the intent of anyone who sponsored this bill to take away government transparency, and only, in fact, to enhance it. Why wouldn't it make more sense to have public records available online so that it didn't have to be subject to a clerk copying 3 years' worth of public meeting minutes and agendas? If you could just simply point someone to the website to get that information. I think that was a reasonable request made, and a reasonable response is in this OPRA bill. I also have heard from my constituents. They also include many, and there are neighbors and our friends that work in government that have been subject to the abuses. People have been sued. These clerks don't like having their name in a caption no matter what happens, and that's what happens. And there's been a lack of predictability of what happens when that case goes to court. I am a lawyer who has been privileged to serve as a lawyer for the public. It's always my privilege to do so at the most reasonable cost possible. I always find it interesting, though, that my colleagues on the other side, when they sue the public entities here, how much they're able to get in response to these OPRA request lawsuits. I think there was an intent here to try to control that. Again, as I might have shared with some of you all who reached out and asked me about why I would sponsor or draft a bill like this. As a lawyer, I find it difficult to predict and advise clients on what the answer will be if you take the attempt and deny an OPRA request. What's going to happen when you go to court on that if there is a lawsuit? We have, up in Bergen County, I was in receipt of an order from a judge fining a public entity $193,000. Who's paying for that? In addition to attorneys asking for in excess of $500 and $600 in attorney fees. My answer is, who's paying for that? It's the taxpayers. And I think the amendments that have been proposed here, and I hope you all support for OPRA, was a surgical attempt to address that abusiveness, a surgical attempt to address the excessive fees that have been awarded under OPRA. That's what we're trying to do here. We're trying to encourage greater transparency. OPRA has resulted in, we talked, Middletown's one of my bigger towns. It's the biggest town in Middletown. And my colleague, Jerry Scharfenberger, when he was mayor, they had to hire 4 people in Middletown to implement OPRA. And that's great that Middletown can afford and absorb that cost, at a loss of probably other fees that they could have dedicated elsewhere for the residents of Middletown. But that's what Middletown did. What about my smaller town like Keyport? If you walked into Keyport and looked at the clerk's office, you'd want to cry. She has processed so far 250 OPRA requests. That's 250. This one little clerk, she's very tiny, who works really hard and diligently to get responses to that. And just imagine, 250 requests by this time of the year. How about, they all don't take an hour, but let's say that she dedicates an hour to each of those. At what cost is that? And if one of those flip out into a lawsuit, at what cost will that be to that little town of Keyport? They don't have the resources of Middletown to absorb that cost. And that's why we have to rein this in. This bill gives a message to the court because there's language already existing in here that's not being interpreted with the fidelity that I think the original drafters of this bill intended it to be. What happens if there's a substantial disruption to the business operations? You could deny that request under the existing bill. Do you think clerks take that risk? Do you think attorneys feel comfortable advising them? Yeah, take that risk, just deny it and see what happens. No, we're all trying to be mindful of the cost to the taxpayer. So I ask you to look at that bill and look at these proposed amendments in that spirit, because I know that was the spirit of what I was trying to accomplish here, as well as Assemblyman Danielson. We worked hard in talking with our legislative leaders, municipal leaders throughout the state, county leaders throughout the state, and we want to make New Jersey as affordable as we can, and this is one way where we can try to do that at a local level, at a county level. Do I feel saddened that public advocates feel like OPRA is their route to root out corruption that's occurring in New Jersey, that they allege occurs, that we all see occurs? No, that shouldn't be the answer. There's a ton of controls existing in all the laws that have been adopted way before I was here that are intended to address those abuses. So I wish, and it shouldn't be incumbent on public advocates under OPRA to root out corruption in this state. There's already those controls, and they should be doing it. So I would encourage my colleagues here in the legislature to consider those remarks, consider the remarks of Assemblyman Danielson, consider the work that was done in all the committees, and I'd ask you to vote yes today on this bill. Thank you, Mr. Speaker.
Thank you, Assemblyman. Madam Clerk, please open the machine for a vote. Madam Clerk, please close the machine, take a tally.
Who was the bill number?
Why did we do
Look, my
that?
screen went blank. You know, I don't know what the number was.
Great.
Mr. Speaker, Senate Bill 2930 has received 44 votes in the affirmative, 25 in the negative, and 1 abstention.
Senate Bill 2930, order in the chamber, please. Senate Bill 2930, having received 44 votes in the affirmative, 25 votes in the negative, and 1 abstention, I declare the bill passed, that the bill take the usual course of passed bills.